I wrote some letters to the members of the Legislative Assembly of BC. There is a problem in the administration that requires the attention of the legislature. The executive and the Attorney General's Department are denying that they have jurisdiction to check the judiciary to avoid communicating with the legislature, and they are asserting that the legislature has no jurisdiction to check the conduct of the judiciary, which is simply not true. The people are always the final check on the claim of any purported ruler. That principle is guaranteed in the Constitution, in the Judges Act, and in precedent from the judges themselves. I believe that the judiciary is in breach of fundamental justice and the executive are running interference because they are similarly implicated. This is a matter that the legislature must consider, as the remedy may involve the removal of a judge, and certainly legislation is required to properly protect the people in a free and democratic society, as promised in the Charter. I'll briefly present the relevant facts. In 2007, I presented the BC Law Society and the Nelson City Police with evidence of obstruction of justice by two lawyers trial fixing. The BC Court Chief Justice is currently being represented by a lawyer in order to avoid commenting on a judicial conduct complaint regarding a judge who agreed with a lawyer for BC FMEP, asserting that he could ignore charter arguments if it was a narrow issue, including requests for incarceration. Federal Attorney General David Lametti fails to respond to Section 24, subsection 1, the enforcement procedure of the Charter. The Attorney General of British Columbia was served with a constitutional question regarding the legality of Federal Attorney General failing to respond to the enforcement procedure of the Charter, along with a constitutional question regarding the constitutionality of the Income Tax Act, Section 238, subsection 1, requirement to file. The response of the Attorney General of British Columbia is no comment. A BC Supreme Court judge does not show up to court on February 14, 2022, to provide a decision on a writ of mandamus on the Minister of Justice David Lametti following evidence of a failure in the rule of law throughout the Canadian legal system. When Justice Leister did finally produce a decision, it claims that all my allegations of misconduct by authority are irrelevant to the charges against me, a continuation of a failure in the rule of law. At the BC Court of Appeal, my appeal is dismissed as a conspiracy theory. This does not reflect reality. My lived experience in British Columbia and Canadian legal system is not only irrelevant, it is not real, contrary to all the evidence before the court, replaced by judicial opinion alone and in a written decision purposely removing the fact that I presented the transcript to the court, the best evidence that any Canadian could provide to prove fraud committed by a lawyer on a court order. Allegations of misconduct by lawyers or the judiciary are removed from the system and dismissed as conspiracy theories, or vexatious litigants, or as the BC sheriff attending court labeled me in his communication with the RCMP, a freeman of the land, in a continuation of the smear campaign to discredit my testimony. I have reported the problem I have encountered to the police of jurisdiction on numerous occasions, with no investigations ever being initiated because it involves the court system. Clearly, the police are on a lower rung than lawyers or judges. Unfortunately, the citizens of Canada are below that, with nowhere to turn unless a police officer, a lawyer, or a member of the legislature becomes involved to properly check the powers of the judiciary. The implications of these judicial rulings is that the public has no rights in the legal system established in Canada. Judges assert that they may legitimately ignore all of our evidence, up to and including their official record, the transcript, being used to correct a court order improperly drafted. Our efforts to access justice in the BC legal system are subject to unresolvable failures in the rule of law and open criminal conduct, with the fact that it is happening in our legal system as their only defense. Clearly, this conduct cannot be justified in a free democratic state, and that is why they refuse to respond to constitutional questions. I filed an application as intervener in the Federal Court of Appeal hearing the matter of the appeal by the executive of the decision of the Federal Court declaring the enforcement of the Emergencies Act to be not justified, illegal, and unconstitutional. My evidence includes the Minister of Justice making false and misleading statements in order to improperly protect judges instead of doing his duty in protecting Canadians. When I replied and corrected David Lametti, I received no further communications. The Prime Minister's office forwarded the matter on to the Minister of Public Safety, Marco Mendicino, who never responded. The submitted evidence was acknowledged and is on the court record, but my further participation in the process was dismissed. The Premier of BC, David Eby, is notified by email and registered letter of the failure of the Minister of Justice to respond to the enforcement procedure of the Charter. In addition, I had communicated the problem previously on September 21st, 2020, by letter to David Eby as Attorney General of BC. On February 26, 2024, I sent a registered letter to the Attorney General of BC, of British Columbia. I received no response. I followed up on June 14, 2024, with a second registered letter. I received a response that they are examining the situation. Unfortunately, given that they all knew of this beforehand and did nothing, that might prove to be a conflict of interest, as is the reality that the BC Law Society is in conflict with their governing statute, improperly protecting lawyers, and refused to provide written reasons for their failure to protect the public, which provides the legitimacy for their monopoly on the provision of legal services. On July 10, 2024, they responded denying that there was a problem. The Attorney General of BC, with your approval, enacted changes to the Legal Profession Act, providing the Attorney General's office with the ability to make appointments to the Law Society's board, enabling them to control the Law Society, and through them, all lawyers, and through that, all potential judges. Given the evidence that lawyers are not a competent authority to properly check their own authority, and the Attorney General is not in compliance with the law, it is a biased party to the conflict before the purportedly fair and impartial court, and it is also not protecting the public interest, as they have a conflict of interest that destroys their legitimacy. Lawyers at the Attorney General's office are asserting that the judicial is supreme and not subject to oversight by the legislature. The judiciary is also refusing reasonable legal attempts to provide legitimate checks and balances. Without the protection of the representatives in the legislature, the citizens of Canada are vulnerable to those abuses of power. The legislature is the appropriate forum to address the problem of law societies and the Family Law Act, as obviously they are a creation of the legislature. Provincial court judges and the administration of the criminal law are provincial responsibilities. So I come with a problem, and a very big one, and denial has been the solution so far, which has been very easy for them but terrible for me and the people around me. We all deserve better. I certainly deserve to be treated better. I have published my story through the legal system and into politics at fundamentaljustice.com. The solution to democratic deficit is to strengthen democracy, which means greater citizen involvement. I suggest British Columbia embraces this as an opportunity for a new beginning, to dilute power, seek transparency and accountability by creating a citizen jury to check the powers of police boards, lawyers, and judges. This will foster greater connection between the citizen and the public service, which will create trust. There are many benefits. An empowered citizen is a powerful force, so much better than a rebellious citizen. It is the difference between inspiration and despair. I would suggest that a random mixture of young persons just leaving school, along with retired persons, and others from diverse working backgrounds would provide a much-needed communication conduit back and forth between the government and the citizens. Bring democracy home so we can enjoy the fruits of our labors and have respect for our country once again. I know this is challenging, but your role as the representatives of the people in a democracy is to check the powers of the executive and the judiciary for abuses. This clearly is such a time. The BC Law Society is a BC Legislature responsibility. The current plan for the BC Attorney General Department to effectively take over the Law Society clearly doesn't protect the people of British Columbia from abuses of government power. A check over the powers of the Law Society to protect the public would best be accomplished by a grand jury inquisitorial system. Nothing else is obviously acceptable for the public trust. It is well known. Trust is earned, not given. The problems of the BC federal judiciary is more challenging, as they are governed by the federal government. But I will be serving every parliamentarian with the enforcement procedure of the Charter, Section 24, subsection 1, in an effort to bring accountability in that forum. I thought I would start the process informally at the provincial level, hopeful that that will bring a response before making this a more formal constitutional issue. The problem of the BC Attorney General is more straightforward. The legal advice of the Attorney General is contrary to the law and the Constitution, and contrary to their duties to protect the public and see that the administration is in compliance with the law. The Attorney Generals are obstructing justice. The refusal to respond to the enforcement procedure of the Charter is followed by the failure to respond to a constitutional question, a refusal to debate the constitutionality of the Judges Act, and a refusal to investigate the conduct of a provincial court justice in accordance with the BC Provincial Court Act. We also have the problem of a failure by the Attorney General's staff to comply with a court order to provide court audio and a refusal to file documents at a BC registry due to allegations of access to justice issues contained therein. Investigations under private prosecutions are never investigated and dismissed arbitrarily. The public is not being protected. Not by the BC Law Society and not by the BC Attorney General. Accountability, transparency, and public oversight with investigatory powers would help to balance the scales of justice. I formally request that the matter of the Weimar Backcountry Ski Lodge Kootenay Experience's Crown Land tenure be re-examined in the context of the above situation and a realization that the public would best be served by the facilitation of compliance and the restoration of the license. I conclude by thanking you for standing up to represent the people of British Columbia. No Canadian should be subject to a judicial dictatorship supported by the executive in the form of the Attorney General's office. Access to justice is a public service which must be protected from corruption by the legislature. This is the exact moment when the importance of the Legislative Assembly shines to truly protect the public interest. British Columbians and Canadians should not be coerced into trusting a legal system that clearly is dysfunctional for the needs of the public. The restoration of trust in our legal system is of vital importance to the national security of Canada. Yours sincerely, Trevor Holdsworth. Please find attached the brief in support of my intervenor status at the Federal Court of Appeal regarding the enforcement of the Emergencies Act, a registered letter of November 30th, 2022 to the Premier of British Columbia, David Eby, registered letter of February 26, 2024 to the Attorney General of British Columbia, Nikki Sharma, registered letter of June 14, 2024 to the Attorney General of British Columbia, Nikki Sharma. Thank you for your attention.